No, I meant to say, when people say Igor is the absolute best, I think it's great out, but I really like the It's got like a beautiful 70s fast. So
You are.
right off the get-go. It's great. Okay. Oh, you got some merch? I always tell. I tell myself I'm going to buy something, I end up always buying something.
Yeah, just pull it out of the way and I'll just.
I'm not going to belittle people, getting attacked, but like for real, touching grass and like connect with your loved ones. Turn it off.
All right, good morning. Ladies and gentlemen, let's go ahead and get started. Senate Judiciary meetings now called to order. Ms. Ogden, if you will, call the roll for us.
Senator Albritton. Senator Bell. Here. Senator Carnley. Senator Coleman-Madison. Senator Elliott. Here. Senator Figures. Here. Senator Gavan. Here. Senator Orr. Senator Singleton. Here. Senator Smitherman. Here. Senator Stutz. Senator Weaver. Senator Barfoot.
All right, we've got a quorum.
Yes.
All right, first on the agenda is HB 202. There are several amendments. Mr. Chairman, Reynolds is here. Of course, you'll remember we had a public hearing, extensive public hearing on it last week. And Mr. Chairman, the mic's all yours.
Thank you, Mr. Chairman. Thank you, members. I know a couple of the members have worked closely with our team on a couple of amendments. I think we kind of worked through the bill adequately last Wednesday. So if it pleases the committee, we can move toward accepting those amendments.
All right, Senator Gavan.
Yeah, I would offer the amendment that's in the package. Begins on line 5 and replace line 93 on page 4 with following.
And that is, that should be the last, it should be 11-1 in your package, top left-hand side. Senator Gavan, would you kind of tell us just generally what that amendment does?
So this deals with is the allowing the plaintiff to, it does not affect the criminal side, but it allows the plaintiff, excuse me, does not affect the criminal side, but allows the plaintiffs to be able to access the body cam beforehand and hope that this would be a resolution. And then it cleans up one of the issues that I brought up from the existing law. It's been the law for quite some time that removes the personal liability in the case a private entity does not have insurance, removes it for the personal officers. I mean, not the personal officers, but the corporate officers. What it does not deal with, and what I'd like to work with Senator from Jefferson on is next year is how do we deal with unincorporated associations like fraternities liability. It is very unclear, and so we left it the way it was on that issue because it is so unclear. But so I would offer the amendment.
All right, got a first, second by Senator Orr. Any discussion on the amendment? All right, Ms. Ogden, if you will, call the roll for us.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye. All right, the bill is amended with Senator Gavan's amendment. Next up, I think, Senator Singleton, you've got a couple of amendments and you wanted to talk about.
Yes, Mr. Chairman. Thank you, Mr. Chairman. I have a couple of amendments. I have my first amendment starting on replace line 16 on page 1 of the following.
And I believe that in the top left-hand is Q7-1, members. Am I right about that, Senator Singleton?
Yes.
Should be in your package. Should be right after the bill or right before the bill in
Mr.
your
Chairman,
package.
point of clarification.
Yes,
I
sir.
think just to make sure, because we also had another video body cam amendment, but it sounded like you incorporated that in yours, because I thought Senator Singleton was going to bring that one. So this is different than that, correct?
Correct.
Okay.
Yep.
These are one of the ones I didn't know about. Go ahead.
Senator Singleton, if you want to explain that, everybody see that Q7-1.
Yeah, what this does is try to allow each state, county, and municipal law enforcement agency where they should collect the following information regarding allegation of excessive force received by agency.
I think that's a different one. If that's the one you're offering.
Hold on, let me make sure. Say it again. No, which one you was on?
Well, I thought you were adopting the one that's in the top left-hand, AR164 Q7-1. Okay, you're on HH-1.
Okay, I can go with the one I can go with the one.
All right.
Okay.
So Q7-1 is the last numbers on there.
Okay, this is the one that established a study commission. It's established a study commission based on, replace line 16 on page 1, the following peace officer immunity, and establish a study commissions to study the effect of the act in the recruitment and retention of law enforcement officers. And it basically just say who should get that report and when that report should be given.
And I've gone over this amendment, and I think it's a well-received amendment. I like the amendment. I'll defer to Chairman Reynolds as to whether or not he feels the same.
Thank you, Mr. Chairman. Obviously, I just learned of this about 8:10 this morning, so that was kind of unusual for me on procedures. But, yeah, I think the intent is good. You know, really a lot of your accredited agencies already do this because they do this as part of their accreditation process. I think a lot of your numbers on many of your agencies are already collected, and I think this is trying to accomplish what we're talking about, what kind of impact it's having on law enforcement. So a friendly amendment.
All right, so members, and again, that's the study commission that's set up that delineates who may be on that study commission. So, Senator Smitherman.
What impact does this commission going to reflect that it has on the citizen? I heard it's talking about what impact it's going to have on law enforcement officers and all that, but what about the regular folk? Them the folk going to get killed, not the police officers.
I'll defer to Senator Singleton since this is amendment.
Well, this is just trying to find out exactly what is going on out there, when excessive force was used, so we at least can have some data as to where it's happening at across the state. It may not have the effect if somebody is dead, but at least we can get reports and know when it did happen, where it happened, so it can be a part of some evidentiary matters if people need to use it somehow. I don't.
Mr. Chairman.
Senator.
And I fully support the concept of what he's trying to do, but I do want to work with him as we go forward because I want a piece in here that says that also what impact it's going to have on citizens.
I agree with you, sir.
Yeah, not just talking about the law enforcement, keeping them and all that. I'm concerned about that aspect. And I would like to talk further with them, just, simply because I think that on many of these situations, while we establish these task force, that it ought to read that the person or their designee, so that gives an opportunity to expand the people who could possibly be a part of it. In other words, other legislators or somebody of that nature. So I just wanted to make that clear that those are two things that concern me.
Thank you, Senator Smitherman. Any more discussion on the Senator Singleton amendment?
Yeah. Mr. Chairman. Senator, why is the initial date of the meeting November 1st, 2027? Are you trying to give them a full 2.5 years?
Can I chime in on that?
First page.
I think in our discussion, the law, if this becomes law, would not go into effect until October of this year, and so that would be October of 2025, and it would give at least a full year of data for that commission to study.
You're actually giving them 2 years.
Well, I think it says no later than November 1st, and that's just an end date that has to be done by then. It doesn't mean that that's the start date on that commission. It's the first meeting at least by then. So, but I would say that that's, maybe even by design. I don't know, but
Yeah,
it gives
when we
us
talked it
time.
through, it was about giving a full year, trying to get at least a full year of data in the study commission.
Yeah, but
that was the emphasis
you're
behind
doing an additional year. Nobody's going to meet unless they have to meet in a lot of these cases. So I would like to work with you in changing that date to an earlier date after that year has been done.
All right, no problem. I don't have a problem with that.
All right, any more discussion on the Singleton amendment? If not, any opposition using previous rule? Senator Coleman Madison would like to be added. Senator Stutz would like to be added as a yes on that as well. All right, then that amendment is adopted. Next up, Senator, I think you've got 2 more.
Yes. I have, this one is 5V4ZDMG, M6-1.
Okay.
Right.
Members, y'all see that?
5V as in Victor, 4, Z as in zebra, D as in dog, M6-1.
All right, if you will, explain that amendment.
Okay, replace line 16 on page 1, the following. Peace officer immunity and require the adoption of written policies governing law enforcement officers. The impetus of this is to make sure that there is a written policy that these officers have to go by, and that we're just not leaving it out there to figure what is constitutional based on something that they can be trained on. We'll know that it is a written policy that they go by. And I think that the gentleman talked to me about, they thought that the study commission could come up with this, but that's at least a year. But what policy will they be going by up until that point in time if we don't have a written policy for them to define what is constitutional or not?
Senator Bell.
Mr. Chairman, you talking about basically like their standard operating procedures, most of them already have
Yes.
now?
Yes,
Okay. So I think, so basically they can adopt what they already have under this bill. They're just adopting their current standard operating procedures that talk about force, use of force, and elevations of force and all of that.
I don't know all what they do, yeah,
Mr.
but
Chairman, if I may.
Yes, sir, go ahead. You
I do
wanna
not
address that
read it
issue.
that way. I read it that a post will develop a policy and everyone in the state of Alabama's got to go by it. This is probably the shortest amendment, but, and I don't want to say it's worrisome, I'm just saying it's a heavy lift. And since we didn't get this till I wasn't notified till 8:10, got here about 8:25 this morning. This would be a tough one. I agree with it. I've said it publicly, and you can read it in the public, that I feel like that agencies should, IACP every year puts out model policies, and they have a model policy on video cam release, and a lot of your accredited agencies have already adopted that. But I would not want to force this on, let's say, the sheriff's in the state, because they're not even APOS certified. There may be some throughout those ranks, but it impacts a lot of different things. I would just ask that we kind of make this part of this study commission.
But Mr. Chairman, but would you think they all need, if we're gonna give everybody immunity, that they all should at least be APOS certified? That way we know they at least got the APOS training. Because if you're giving immunity to someone who hasn't gotten APOS training, that should be a liability. That's negligence and reckless right there on their part. If they haven't got APOS training, then we should at least have an amendment to say that every police officer should be APOS trained in the state. Because if that is the case, I can't see us giving them immunity and they're not being APOS trained.
Right.
Mr. Chair.
You're
Senator,
saying municipal officer, I mean, we could talk about that, but we couldn't about to address whether our sheriffs in Alabama need this kind of certification. You're talking about a heavy burden on our counties and our cities.
People are dying. That's a heavy burden on families.
They have their own
in
training.
that
It's just
split
not
second we're
APOS.
talking about, and then we're talking about giving them immunity from that loss to that family. So we at least need to make sure that everybody's trained properly across the state.
Senator Elliott, and then Senator Figures.
Thank you, Mr. Chairman. I agree with Chairman Reynolds, the bill sponsor, on some of the specifics of this. While I think, especially in my district, fairly sophisticated departments and sheriff's office, but this is a model written policy that may or may not exist currently from APOST, and then it specifies what shall be in the policy, and that may or may not differ from what policies are currently in effect by our local PDs or our local sheriff's office. I have concerns about specifying what shall be in the policy and then mandating a model policy that I'm not confident exists currently.
It's Senator Figures, and then Senator Coleman Madison, then we'll go to Senator Smitherman.
Thank you, Mr. Chairman. I think if we're going to give immunity to everybody, then everybody should operate under the same rules, policies, and regulations. Immunity is a big thing, a big thing. And while I appreciate our law enforcement, I've stood with them on many pieces of legislation, I do think if we're going to give immunity, it needs to be very clear. It needs to be simple of what's required so that from one case to the other case, you don't have a variation of what they're going to accept and what they're not going to accept, or what they're going to consider right and what they're going to consider wrong. So I would like to see an amendment like this and I would like to see the professionals involved who deal with this on a day-to-day basis to know exactly what that force can be, things that happen or could happen or whatever, that they are on, that there be that special committee to do that, not the study commission, because the study commission is put in place to look at the effects of the acts that have already happened, and then to go forward from there and make their recommendations. So to me, it's nothing like transparency and everybody knowing the rules and the regulations so they can all be on the same page and be all treated the same.
Well, I think every agency that has policies, they should have a policy. I mean, the consistent language there, no matter where that policy is our constitutional law. I mean, that's the basis of these policies. They still got to go by the Constitution.
Well, isn't there
But to
something?
force, to stand here this morning and with this language and force this on all the agencies, whether it be state police, local police, sheriff's departments, that's a heavy lift.
But Representative, isn't the cause of some of these acts by some law enforcement people because they haven't had the proper training, and that's what ends up happening with the fatalities in a lot of the cases, is that they haven't had the training. So if someone's going to get the immunity, I think they all need to have the same set of the same criteria and be on the same level of training if they're going to get immunity. It doesn't make sense for someone to get immunity and they didn't even have the training, and it was something pretty basic that they knew they should have done instead of taking someone's life or gone through something to try to prevent that. So that's why I think we should have it.
And our APOST standards collects that. They conform our officers to that today.
But you said some people don't have a post training who are going to be immune, right? Is that what you were saying, Senator Singleton?
Yeah, that's what he
sheriffs,
yes.
not sheriffs, not elected sheriffs, but the sworn deputies in Alabama do not have to be APOST certified today. They have their own.
And we're going to
they
give
have their
them
own
immunity. Thank you, Mr.
All right,
Chairman.
That's based on the Constitution.
Senator Coleman Madison, then Senator Smitherman, and we'll vote on the amendment.
Thank you, Mr. Chairman. The concern that I have, Representative Reynolds, this will become a state law, right?
Yes, ma'am.
We look at everybody around this table, we all represent different areas. It's not local. So if we're going to pass if we want it to be different for everybody, then all of us will go back to our respective, and as they already have, different. But throughout the state, you have all the law enforcement officers, and I work with the ones in Jefferson County and Birmingham. But they all have different ones, and we represent different cities, and so we know that that's different. So the problem I have is that, is this going to become a state law? Are we all expected to abide by the same rules? Are citizens expected to know what those rules are as well when situations like this happen? So you said, well, go by the Constitution. Well, that's what we're doing. But right now, we're leaving it up to everybody differently, and hopefully, in doing this, is one of the things that we hope that we'll be able to do is to decrease the number of deaths that are caused by things like this. And certainly, while we say we don't want to force this on the agencies, what we don't want to do is to have an accident happen in a split second, and that's really all you have. Before I came down this week, I had a call from, well, not one of my constituencies, one of the neighboring cities in Gardendale, and this person was a chief magistrate in that particular city, but fell into the same situation where her son was a victim. And as she said, that they stopped him, and he was guilty of the reason why they stopped him. He ran 2 car lengths and stopped. Hands up, decided not to run. But the whole 9 yards is where is his treatment of the arrest. He was slammed to the pavement, busted skull went into the brain and everything. Bottom line is that he's dead. The officer out, free. Again, and maybe we could say that was his discretion as far as, but if a person is surrendered, hands up, was that force necessary? Under this, we're going to say, and she was adamant, she says, I am definitely not for immunity because there was no reason for the treatment that he received, and certainly you cannot, we can't give life. So that family has a loss and they are suffering. I just think that we'll be giving them a blank check, on this. I'm seriously have some concerns because as I looked on different pages of this bill and the way it is described, especially on page 7, 8, and 10, 9, and 10, just the language that was used in here, and in any civil action against a law enforcement officer, in his or her personal or individual capacity. Premise on conduct performed within the law enforcement officer's discretionary authority. That's a mouthful. That kind of like,
Well,
whatever I do.
That's related to what you just described about the escalation of force. And I don't know the details of the case you described, but something prompted an escalation of force. And you want that in place because you don't want somebody to show up and shoot an offender that's unarmed and not pose any threat to anyone else or the officer. That's why they have, when you literally show up, your presence as an officer is the beginning of that escalation of force. And that's based on the suspect's actions. But if you can, Mr. Chairman,
let me clarify. The camera indicated that there was no force on the victim's part. He did not, resist other than that, and the excessive use of force and the way he was treated that caused his death was not necessary. That was excessive use. But still, that officer got off. So now, without having something, and maybe you could say that, well, okay, for that particular police department, their rules said that okay, it was okay. But without having anything that's statewide, that's going to govern everybody, I don't know.
Again, Mr. Chairman, all due respect, it's the Constitution. And let me refer back to last Wednesday when I talked about Tennessee versus Graham, or Tennessee versus Garner, Graham versus Carter. Law enforcement officers who use force constitutionally while carrying out their duties are immune from prosecution. Again, law enforcement officers not immune for any unconstitutional use of force during execution of their duties. So if they operate outside the scope of their duties, they have no coverage.
Senator Smitherman, and we're going to vote on the amendment.
Is that case that you just mentioned a Tennessee case, Alabama case?
That's a Tennessee case.
Okay. All right. First, I want to say that, and I think the lawyers can follow what I'm saying. You probably can too, but the lawyers definitely can. Just the credence that we're giving that case is not of the level to be applicable here, because that is stare decisis. That is just what that one court has said. That is not a statute. That is not a law. No other judge is bound by that ruling whatsoever in the United States. That's the first thing. So I don't want anybody thinking that, hey, it's in place. We got that in place. We don't have anything related to the court in place other than an out-of-state court's decision. And we don't know what the merits of them making that total decision. Just like you said, the other thing you didn't know about, she was saying about the arrest. We don't know anything about that. And we're putting our linchpin on this court thing as if to say, yeah, the green light, we got something in place to do all the things. We don't have anything in place to do that. The Constitution, let me just say this. Knock on wood, I taught constitutional law for 25 years to seniors in law school. I got a little understanding of it. The Constitution does not protect citizens from the actions of the police officer itself. It does not lay out the steps the officers ought to do A, B, C, D. It says that if you violate certain constitutional rights we have, you're subject to that. In this bill, we're not going to even get to that. That little review group that looks at them before we go to the court, they're going to stop right there. The people not only even get a chance to get to court to do the things that you're talking about based on what this bill is set up to. And yes, you're right, it takes a lot for those areas to get up to the level that they are talking about. But that was one of the problems back when we had the situation with the, I don't know, George Floyd, whatever it was, because even in Birmingham we had some protest information. We got together, and you may have been in that meeting, I'm not putting you there, but we got together with APOs and everybody else to try to come up with some way to make sure that these people are not going to get just slaughtered and killed. And out of that, that's how we evolved from the information database that we passed the law and funding, so that we would try to get check background of officers so that they would not get in there like bullies and et cetera, et cetera, et cetera. But one of the problems was right where we are. is that you got so many inconsistent shooting policies in this state that you got some that don't do anything till you go to a model policy, which is the city of Birmingham. It's a model policy. And I'm sure Hansel may have one or not, but the inconsistency, what they're saying, that has to be addressed. And it has to be addressed. And I don't know why we're rushing that we got to have this into law in 3 or 4 days. I'm saying even if it passes, the implementation should be tied to this training, whatever length of time it takes to get these folks trained. Ain't nothing gonna happen in this world if we wait 6 months, 8 months, 10 months, whatever it takes after if the law passes to get these people trained. But otherwise, if we don't, you're gonna have that situation. I mean, you got all levels of people who are officers. You got people from the basic level of high school all the way through to people that's got masters. And you got to understand just that variation in between. So we've got to make sure that they have a set standard of what they can be measured by. Right now, we don't have a set standard. Whatever this little area here, that's the set standard. Right. And for this one, it's over here. So if I leave out of this area and go in here, I'm subject to a whole different situation than I am here. Even as a citizen, I need to know consistently when I go from county to county, city to city, that I'm on whatever it is I got to deal with, it's going to be the same. And this bill does not do that. So that has to be corrected. We don't need to rush under the name of saying we got this pass, hooray, and folks out there falling down, dying. You know, we don't need that because it's like she said, if it's one life, that trumps everything else that we're just talking about because that person, unfortunately, we can't bring them back. So yes, I support that concept of what they're saying, that these officers have to be trained by the same training standards. And if we don't have that, like you were saying about they don't have to be certified, then we need to start certifying them. I mean, it is. You know, we need to start certifying them. Thank you very much.
Thank you, Senator Smitherman. Ms. Ogden, if you'll call the roll on that amendment.
And the sponsor wouldn't consider pulling this amendment and working toward that. I'm not saying it's a bad idea, Senator. I'm saying I'd love for everybody in the state to be under one policy, but to get this morning at 8:20, I mean, we just hadn't had time to work on the details.
Well, my thing is, if we're going to work on it, then I don't want us to be rushed trying to get this bill on the floor and get it passed. If we're going to be sincere about working on it and getting it properly right.
Let's see what happens on the amendment. If the amendment doesn't get adopted today, I would suggest that, you know, his comments, the chairman's comments are sincere, and, you know, he intends to work on that to maybe have a floor amendment if it's agreeable. Did I hear you right about that? Ms. Ogden, if you'll call the roll.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman-Madison? Aye. Senator Elliott? No. Senator Figures? Aye. Senator Gavan? No. Senator Orr? No. Senator Singleton? Yes. Senator Smitherman?
Aye.
Senator Stutz? No. Senator Weaver? Senator Barfoot?
No. All right. We did not adopt that amendment. Senator Singleton, I believe you have one other amendment.
Did I have one?
Should be.
It is DG 9RYHH-1.
Members, did y'all hear that?
Which one is it?
The DG 9RYHH-1.
Okay. Oh, yeah, this is the one that sets up the database? Yeah.
If you could explain that amendment real quick, members.
It deals with each state and county municipal law enforcement agency should collect all of the following information regarding allegation of excessive force: a description of the type of excessive force, a description of the race and ethnicity of the law enforcement officer and the victim of the use of force, which are the subject of the allegation. The information shall be annually distributed to the Alabama state law enforcement agencies and to the legislature when we're in session. And this bill should take effect in October.
Chairman Reynolds.
Many accredited agencies already do this, and I'll accept that amendment.
Okay, so it's a friendly amendment.
Yes,
You
sir.
see that? Any discussion on the Singleton amendment then? All right, if not, Ms. Ogden, will you call the long roll on that?
Senator Albritton?
That's the amendment. It was a friendly amendment.
Senator Bell? Senator Carnley?
You don't know, but
Senator
just
Coleman
because it's
Madison?
friendly.
Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton?
Aye.
Senator Smitherman?
Aye.
Senator Stutz? Senator Weaver? Senator Barfoot?
Aye.
10 to 2.
The amendment is adopted.
One more
on the-
question.
All right, on the bill as amended, Senator Singleton with the question.
One question here. Is there anything in this bill? I was looking at some of the original language of this bill that's been stricken out. And it talks about nothing in this subdivision constitute justification for reckless or criminal negligence conduct by a peace officer amounting to the offense against or with respect to person being arrested or to innocent person who is not seeking to arrest or retain in custody. I see that has been stricken up, but does this bill encompass criminal recklessness and criminal negligence in this bill against a peace officer?
Well, you want to show me
Would
what
that
you
be the-
Googled there, or do you
But
want me
that,
to-
it was some old language, and I'm just reading back. What y'all had struck this out.
Show me where that is in the current version of the.
I don't know where it is in the current. I'm just looking at
Well, let me answer it. Just
in the Ingress.
that's exactly what they a judge in
gross-
that 45-day hearing would base his ruling on, is whether the officer acted recklessly or within the scope of their duty.
So that's the unconstitutionality part of it.
That's part of what that judge would determine, both on the civil side and the criminal side.
Senator Smithman.
Can you tell us what page and lines that what you just said is on in your bill?
HB 202,
Not
the
you,
engrossed area. He didn't know where I was reading from.
Oh,
I was
okay.
reading from line 424 in the engrossed version.
It's,
Page 4.
you mean in the bill itself?
Yes, it has been stricken.
The bill that he has?
Yes,
And it's been stricken out?
yes.
Well, Representative, how then is that going to be addressed if it's struck out in the bill?
Well, I'm looking at my substitute, and there is nothing struck out on page 4, so.
Page 17.
Page 17, lines 424. That's subsection C of existing law 13A327. And I believe the reason that that's struck is because there would be some changes, obviously, to existing law. So I think that's the reason that's struck.
Well,
I'd like to see where it encompassed it back in.
What is the changes then? I was requesting that he explain that.
Mr.
What
Chairman.
you just said, explain that to us, please.
well, again, you got to remember.
In the bill now.
Yeah.
Show us in the bill if you don't mind.
Well, again, generally first, this bill has been in place for, 31 years? And so, as you've heard me say before, I think we've done a good job clarifying when immunity is justified and when it's not related to the bill.
So if
Hold
You're-
on
and
just a
then-
second, hold
and
just a
then-
second.
And then to answer
Senator
the second part of
Smithman.
your question on page 18, the law enforcement officer shall be justified in making any use of physical force against a person if the use of force is conduct performed within the law enforcement officer's discretionary authority and does not constitute excessive force as provided in the subsection.
So do you put that in to replace what was scratched out with the line?
Well, it's related. The verbiage, as you see, is
So
different.
that's what you.
Yes,
I
sir.
just want to be clear. That's what your response is to.
That's
what
part of it, yes, sir.
What's the other part then?
Well,
You talking about this
Chairman,
section?
I can read this.
Yeah.
Yeah, I mean, we need to know.
Hold on 1 second. I think the answer to that question, and I'll defer to you, but that's struck out of that section because that's an old section. And then if you follow on down, it talks about no law enforcement officer shall be justified as provided in this section for any use of physical force against a person if the force violates that person's rights. So
correct. That's
I
a-
think
that's
that
the
any
second
force
subsection, if
would
you want me to read
encompass the recklessness or even the criminally negligent part. Am I correct, Mr. Chairman?
Yeah, sure, but I think you gotta have the A to go with the B,
Right.
so if.
And,
if you want me to
the
read
A
the B.
says that it says that a law enforcement officer shall be justified making any
As-
use.
as provided in this
I'm reading,
section.
Mr. Chairman. I'm
As
reading on-
provided in this section.
Mr. Chairman, I'm reading on page 18.
Yes, sir.
In your bill. The law enforcement officer shall be justified in making any use of physical force against a person, any, if the use of force is conduct performed within the law enforcement office discretionary. They go back to what they just said. Man, anybody been trained, ain't they? What discretionary do they know to use? Other than there goes somebody, I'm finna bust a cap on them. That's all it is. Now, let's just say it for what it is in this bill. It is a green light, like I said, to kill black folks. Ain't only black folks, but it's a green light to kill them.
Mr. Chairman,
we saying, right,
I've been through that
I
3 or
would
4
just-
times about the escalation of force.
As I said, this right here opens the green light for them to do anything in their discretion. They can walk in here now, and in their discretion, they look at me and they say, you know, hey, he looked like a threat to me, and bam, bust a cap on me.
Senator
And
Smithman,
this bill,
let me address something along those lines. I think that part's true if you read only A, but if you read B in with that, is as long as it doesn't violate any constitutional rights that an individual has. I think, in my mind, that sets that A apart.
but what in the Constitution then is going to protect someone before they die? Because all this is that after they kill them, then their constitutional right kicks in that you violate their civil rights maybe and whatever. But we're not going to ever get there because of that little committee group review up here. That's the first thing. But secondly, there's nothing in that Constitution that protect people while they walking around alive. Because this is what their life is going to be governed by. The Constitution ain't no section, no nothing says anything that bound them to go through a certain procedure or how you supposed to conduct yourself and give them that knowledge in that Constitution. We keep going back to the Constitution. Constitution don't do none of that. None of it. None of it. Thank you, Mr. Chairman.
Yes, sir. Ms. Ogden, if you'll call the roll on the bill as amended.
Senator Albritton? Senator Bell?
1 second. Procedurally, I believe that's got a motion for favorable by Senator Gavan, second by Senator Orr. Now, Ms. Ogden, if you'll call the roll.
Senator Albritton? Aye again. Senator Bell? Senator Carnley? Aye. Senator Coleman Madison? No. Senator Elliott? Aye. Senator Figures? No. Senator Gavan? Aye. Senator Orr? Aye. Senator Singleton?
No.
Senator Smitherman? No. Senator Stutz? Aye. Senator Weaver? Senator Barfoot?
Aye.
9 to 4.
All right, bill's given favorable report as amended. Thank you, Mr. Chairman. I would could ask y'all to continue the conversation on the Singleton Amendment. I think that would address some of Senator Smitherman's concerns as well. So, thank you.
Thank you, Mr. Chairman.
All right, HB 42, Representative England. Of course, we had a public hearing on this last week. Representative England, your floor is all yours.
All right. Thank you for recognition and also allowing me to present this bill. We did have a public hearing on it last week. All the bill does is add back 3 words to the code that were taken out a few years ago when we passed a bail reform bill. And it adds back the words "a part of," which allows the judge in a case to do partial bonds, percentage bonds.
All right, members, any questions or comments on the bill? It was presented last week and had an opportunity to review it. All right, if not, we got a motion for favorable by Senator Singleton, second by Senator Coleman Madison. Ms. Ogden, if you'll call the long roll. Senator Carney.
Appreciate you bringing the bill. I've reached out because I don't know bonds or anything about them. I reached out to my judges and my sheriffs, and so I'm voting based on what they said, not what I think as far as how I should do. So I just wanted you to know that. Just That's where I got my decision.
All right, thank you.
Good, always good to get information from the folks that are involved in that process. So, Ms. Ogden, if you'll call the long roll.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan?
Pass at the moment.
Senator Orr? Senator Singleton? Senator Smitherman?
I'm gonna pass at the moment.
Senator Stutz?
No.
Senator Weaver? Senator Barfoot?
Aye.
4 to 6.
What does Senator Smitherman?
Aye.
What's
Now we're at 5 to 6.
5 to 6.
Yep. All right.
Okay.
Sorry, Representative England.
All
I'm
right.
sure you'll be back next year.
Oh, yeah.
Understand?
Thank you.
Thank you. All right, next up is HB 146, Representative Pettus. We carried this bill over last week. I have an amendment to offer on the bill. Give me 1 second. Members, you should have this amendment in your package. I think the sponsor would see this as a friendly amendment. The bill basically, as each of you already know, WIO application would not be able to have a youthful offender application if the individual were charged with capital murder or intentional murder. This amendment clarifies the fact that if you're charged with one or two of those and it's later amended to something that's not intentional murder or not capital murder offense, that you could receive WIO hearing. Senator Smitherman.
I move favor report on your amendment.
So we've got a motion for favor and second by Senator Gavan. Ms. Ogden, if you'll call the long roll on the amendment.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan?
Aye.
Senator Orr? Senator Singleton? Senator Smitherman?
Aye.
Senator Stutz? Senator Weaver? Senator Barfoot?
Aye. All right, the amendment is adopted. Back on the bill is amended. Members, any questions or comments? Yes, ma'am.
Since I'm the layperson around the table, along with Senator Stutz over there. So what kind of crimes would fall into this category specifically, you know? And you'd have to kind of break it down to me.
I think there are two, and I don't want to jump ahead of you. You certainly jump in your bill, but there are two. This bill would only say that if you're charged with a capital murder offense, you no longer could get youthful offender status. Or if you're charged with intentional murder, you could no longer get youthful offender status. Under the youthful offender law, if someone receives youthful offender status, the maximum punishment would be 3 years. And so it just takes those two crimes out to where an individual under the age of 21 could not receive youthful offender for those only those two crimes. And that amendment actually says, however, even if you're charged with those two crimes, if the DA, if there was reduced at some point in time for whatever reason, that you could be considered for youthful offender status.
Okay.
Mr. Chairman,
Senator Singleton.
but under current law, don't the judges, based on the crime, don't they have the discretion to try a youth as an adult already?
Yes, I mean, depends on, there's an automatic transfer from juvenile court, and then there's a procedure where through juvenile court, there's a hearing, and then someone is sent up under the age of 21 or under the age of 18, sent up to adult
So this
court.
will automatically put it under there without that hearing?
No, I don't think it does anything about the transfer procedure, whether automatic transfer or the hearing at juvenile. Is just when that individual, if he's the person is under 21 years of age, is in adult court, and if they're charged with those two offenses.
Understood. I just want to make sure we wasn't taking away those procedures.
Yep. No, that doesn't affect any of those transfer procedures, either the automatic transfer or the hearing at juvenile court. So, members, any other questions or comments on the bill as amended? All right, Ms. Ogden, if you'll call the long roll for me. Oh, we got a good, I'll move in favorable for the bill as amended. Got a second by Senator Elliott. Ms. Ogden, if you'll call the long roll for us.
Senator Albritton? Senator Bell? Senator Cornley? Senator Coleman Madison?
I'm gonna vote aye on it.
Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton?
Aye.
Senator Smitherman?
Aye.
Senator Stutz? Senator Weaver? Senator Barfoot?
Aye. All right, thank you, Representative Pettus. The bill's given favorable report as amended. Next up, you've got you're the next one on the
Yes.
on the docket, HB 492. If you'll give us an idea of what this bill does.
Under current law, if you're under 16, you cannot be written a citation. What this does is says a 14 and 15-year-old be treated exactly like a 16-year-old on the water and in a motor vehicle.
And we're talking about tickets, and when
Yes,
you
sir,
say
just writing a
citations,
ticket.
we're
Yeah,
talking about
ticket.
tickets.
Yeah, at current law, if an officer stops a 15-year-old with a permit, he cannot write him a citation. This will just allow him to write a citation.
Am I correct that at 14 you can drive a motorcycle now?
Yes, sir.
And that's
With a
probably the
license.
reason for the 14-year-old
And also a jet ski at 14.
a jet
This
ski.
it does both. It does the water and on the road.
Understand. Members, any comments or questions? Senator Singleton?
Does this go on his record? As a
Yeah,
juvenile?
it'd be on the driving record, yes.
On his driver record as a juvenile?
Senator Cardinal?
No, cannot. Well, they're not, under current law, now, what current way, you have to go through juvenile court, you have to do a summons and all that. It's still, that's the way you do it, is you just can't write the ticket.
Yeah, I know I've seen in municipal court occasions where you have a juvenile in municipal court, and there was always some question about whether or not that was the proper venue or not. So I think this cures, that's what you're trying to do with
Yes,
this
sir.
bill, is that right?
Yes, sir.
Senator Coleman
Uniform.
Madison?
Yes, sir, Mr. Chairman, this goes back to the first bill that we had. All these hodgepodge things, and people don't know. And even we as legislators fall into that same trap because there's no standard. And everybody's doing their own thing. So,
And this will set a standard.
yes, at least on this one.
Yes, sir.
But it won't do anything
ma'am.
about the first bill we turned down.
Yes.
All right, Senator Elliott?
Mr. Chairman, are the 14 and 15-year-olds not still juveniles, though?
They are.
Okay.
16-year OS too. Currently, it's 16 and above you can. This just makes it 14 and 15 because they can get licensed.
Senator Smitherman?
How, is it the bill where you supposed to call the parents?
No,
No,
sir. That's the next one.
Oh, that's the next one?
Yes, sir.
Oh, okay.
So
Okay.
if that one goes through, if they issue a ticket, they will have to call the parents on these. Or make an effort.
All right, members, any more questions or comments on the bill? All right, Ms. Ogden, if you'll call the roll.
Senator Albritton? Senator Bell? Senator Cornley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton? Senator Smitherman? Senator Stutz? Senator Weaver? Senator Barfoot?
Aye.
9-2.
All right, bill's given favorable report. Thank you, Representative Pettus.
Thank you, Mr. Chairman. Thank you, members.
Next up is HB 285, Representative Kiel.
Thank you, Mr. Chairman. HB 285 is the parental notification bill, Senator Smitherman. And so you may know this or you may not, but your child could be driving your vehicle using your gas, your insurance. You're liable for that child. But if that child were to get a ticket, you may never know about it. I know if my daughter got a ticket, I might not ever know about it because she has a job, has her own money, and could pay her own ticket. And so it's your vehicle, it's your child, and I would want to be able to parent my child if that were to happen. I spoke with Chairman Barfoot about having the person speak very briefly about why this bill came about and how I found out that my child would not get a ticket if that happened. And so I would ask, Mr. Chairman, if it's okay for April Vafius to come say just a few words to you.
Sure. Thank you for coming to committee today, and we're happy to hear some comments that you have.
All right, thank you. I'm April Vafius. I'm sort of nervous. HB 285 is important to me because June 17th, 2022 was the last time I saw my oldest son. He died in a car accident the next day, and he was killed instantly. He was not wearing his seatbelt. His girlfriend, Lexi, died 4 days later. She was also not wearing her seatbelt. After he died, I found 3 traffic citations for not wearing a seatbelt. And they were all in our hometown, and I had no idea. I am the kind of person that a seatbelt is important, and I never left the driveway without my seatbelt on. I always told him to wear his seatbelt. I even watched from the front, dining room window as he pulled out of the driveway to make sure that he had the seatbelt on before he left the house. So I had no idea that he was in the habit of not wearing his seatbelt. I honestly thought if one of my kids got a ticket that somebody would notify me, that maybe there would be a letter or the insurance company would notify. I don't know. I thought I would be notified. I thought I would have a chance to try to correct my child, and I didn't have that chance. This bill will not help me. My son is already dead. My youngest children will be 19 in July. They'll be too old for this bill to help me. But I hope that it could help somebody else. That, maybe, I don't know if you have children, but it could be your child or your grandchild who gets a citation, and their parent should have the opportunity to address that, to correct that child, to ground them, take their keys, to do something. So I hope that you just do the right thing.
Thank you for coming and for sharing your story. And, there's a lot of legislation that comes through here that's, associations or trade groups bring, but sometimes the most valuable ones that we hear from our constituents. And I know Representative Kiel has been an advocate on this position. I see Representative Underwood back there as well. And I appreciate you sharing your story and giving us some guidance on this. Senator Bell, did you have any comment, question?
It's hard to talk about this situation, but as a former law enforcement officer, this is just about, I'm not going to say impossible, but it's hard to do that. I've been out there on the road. I've written tickets. It's just, I know the bill has been amended to make a reasonable effort, but what is a reasonable effort? We keep putting guidelines and keep putting everything on law enforcement. And I just, I've got to vote against this just from being out there and writing tickets and knowing what goes on. There's just about no way. How do you find out what the driver's emergency contact? It's just things of that nature that how do you know the phone number they give you is the right phone number? I've called parents before in a juvenile situation at a house party, and they wouldn't have not a single one of them give us the right phone number. Fine, we just loaded them up and took them to the sheriff's department and said, when your parents come here and provide ID, we'll release you. But they give us the wrong number, and half of them nobody answered because it was at night.
Mr. Chairman, I can answer a little bit of that. So we worked with Aaliyah on this bill last year, and during the off season, after we were out of session, during session, somebody had the same question. How do I get the phone number if I'm sitting on the side of the road? How do I know if it's a phone number that I can call? Aaliyah was proactive after session last year, and now when a child fills out their permit or the parent fills out the permit application, they do now list a number on there. And so when the officer pulls the driver's license up on the side of the road, a number will come up and they'll be able to contact the parent. And we're not asking to contact the parent. All we're asking is to attempt. And we even say in there, it's a phone call, it's a text message, or a letter. If you decide to do a form letter and stick it in the mail, the officer doesn't have to do it. There could be a staff member do it. You know, somebody, the dispatcher, whoever could do that. So that.
I mean, but what if they make an attempt and then something later happens and then the officer's trying to prove he made that attempt because it's 6 months down the road or something, and something happens to a child, and then I can speak, I guess, bad against lawyers because I am one, and then the department gets sued because you didn't make a reasonable attempt, and then the officer, how does he document that? How does he remember that, I guess, a year later or a year and a half? Because I can remember testifying in cases, and by the time it come to a traffic ticket come to court, I'd look at it, and I had no memory, and I'd say, I wrote it, but I really don't remember I don't remember this, because unless they back-talked you or unless they fussed with you or unless they made some scene, you didn't remember half the tickets you wrote. You know, now luckily they've got video to go back and refresh their recollection, but I don't know, and I've had several departments contact me, I guess because of my history of where I worked, and those are the questions they were asking. And look, I agree, parents need to be involved as far as knowing what's going on and all that. I think it's putting a hard task on the law enforcement officer.
Senator Smitherman, then Senator Figures, and then Senator Carnley, and then Senator Weaver. If y'all can remember that order.
Thank you, Mr. Chairman. I too echo the sentiments that the senator across from me just echoed. I've had some contact with law enforcement. I stepped out to ask both groups, because if you could remember, I kind of expressed my concern when we talked about this bill. But I talked with some people in law enforcement, and just what he just said, the first thing they told me, and I'm, of course, you know, I'm in a city that's, you know, metropolitan area, a lot of folks. They said, look, you know, I got to go out here and try to catch these bad guys. I mean, I can't spend all this time running down people to contact them. And they were saying about this support people, the dispatchers and everything. They talked about that. But the other thing I did, and I'll say this, and then nobody else can relate to it but you, but last Friday, I was in Lincoln, Alabama, at Lincoln High School at the sectional track meet for all the schools in this section of the state. And so not only Rams' track team, but I got a chance, because, you know, we know a lot of my other schools, and I asked those kids, I said, if you get stopped, I said, you know, and I told to them, all of them laughed, and they said, you know, I'm going to get my partner's number. I'm going to do this. I'm not going to do that. And yes, I understand that, what he said about the permit part. But prior to that, you know, if a person, to get that information, to run it down, that officer's going to have to sit there for a numerous amount of time before they can access that information. If we talking about they can get it later, they're going to be going to the next call. If they're out there dealing with somebody shooting or whatever, they ain't thinking about that they're supposed to call somebody. And it's going to get back to what you said. Yes, lawyers going to have a field day, because it doesn't matter that he's got to go to another call. The law says you're supposed to contact these people. And so I'm fortunate. I understand, you know, even the feeling of losing someone. I lost a son, you know, and so I understand. But it go back to what you just said, and I keep saying this: we make laws, and we don't think about the incidental effect of laws. We just see going straight down the road, and, you know, we got to do this. But all this stuff that you and I are saying is these incidentals that I be talking about in this law, those are the incidentals. And it's going to be a nightmare trying to implement and enforce this from the officer standpoint.
Senator Figures.
Thank you, Mr. Chairman. My heart goes out to the mother in the loss of her son, and I applaud her for trying to bring less pain or prevent that kind of pain for other parents. I look at things as if there's a will, there's a way. I do understand what the senators are saying about the increased responsibility on an officer. If there is a way to get with Aaliyah to do this electronically so that it would be automatically a notice sent out once that ticket goes into the system, and knowing that that is a juvenile, and as you say, they are getting the parent's number already, that if a ticket is given to a juvenile, then it would electronically send a letter notifying the parent. I think that is one way to do it. And as I was sitting here, I was also thinking another way to do it would be if the parents had access to go online to check somewhere with their child's driver's license, perhaps, to see if they have been ticketed. And they can go to that website every week or, however often they want it to go. I would think that would be a way to do it, because I do support the idea. I had 3 sons, have 3 sons. They're all grown now. But yeah, you sometimes you don't find out something until a letter comes in the mail, then it's too late or whatever. But you know what I'm saying. So I think where there's a will, there's a way. So if we could work with Aaliyah to do that, I think we could solve the problem.
Thank you, Senator Carnley, then Senator Weaver, Senator Gavan, and Senator Bell, and then we're going to have a motion on it.
Might as well, we've all spoken. So.
Yeah.
No, mine was similar to what Senator Figures was saying, because, and I mentioned this last week, like if there was a way to have a ticket that was specific to 18 and under, where, the parent had to sign off on the ticket before it could be paid or go before the judge, and put the burden, on the child, the person who gets the ticket, and the parent rather than law enforcement, but make sure they get it. And I'm with you. I think there's some way electronically, they already have the date of birth. Anytime that driver's license that's below a certain age gets a ticket, the system either sends it out, or I believe there could be a way without this and forcing it on law enforcement to shoulder that burden. So, I think we can, and hopefully we will.
Because even if you didn't know the parent's name, it could say to the parents of Joshua Smith or whatever.
Senator Weaver.
And I won't echo all these points again because many of mine are the same. And I want to thank the advocate, I know her name was April, for being here, and I'm sorry for your loss, and just thank you for your work, because this is how we make a difference in the lives of families in Alabama. After speaking to some of my law enforcement officers, I have some of the same concerns. The concept I fully support. I agree with Senator Figures. I think these parents do need to be notified. There is some way that we should do that, but I do worry about the burden of proof being on the law enforcement officer there at the time.
Senator Gavan, then Senator Bell, and then Senator Coleman Madison. Well, everybody's going to get a chance. Senator.
So, I've told this group before, I have defended police officers in the past, so I certainly, respect in civil matters, respect some of the things that they've got to go through, but I don't see any way that the failure to notify a parent under this would be the proximate cause for liability in a subsequent lawsuit. I think we can clarify that in the bill easily enough. I know there are a lot of people who have qualms with this. I will be voting for the bill and hope that we can get it out of committee. I understand that it's going to probably need some work to satisfy some people before it gets there, but I don't accept the liability argument on the police department.
I echo your comments, Senator Bell, and then Senator Coleman Madison.
Chairman Barfoot, could I say that I worked with Aaliyah, the Sheriff's Association, the trial lawyers, the county commissions, anybody that called and offered any kind of amendment or anything like that to make this more palatable for law enforcement. I took every opportunity to sit down with them, got them all in the same room. And so this has been massaged a long ways from what you passed last year and was on the calendar in the Senate last year.
Thank you. Senator Bill, you had a follow-up comment?
Sam's not here, is he, with Aaliyah?
He just left.
If you're on probation and parole and you get pulled over, there's an automatic notification that goes to the probation and parole officer. What if Aaliyah developed in their software system when the person, that driver's license number, it relates, when they get it, that number that they're collecting, that it sends an automatic text to the emergency contact, and it's done through the computer when it's run in the database. And I would think they would have that ability. It would take a little bit to build that, but that may be a way based on what Senator Figure's saying, because they're already doing it. Probation and parole's already get notification when somebody's pulled over. So that may be a way to do the notification. That's just a thought.
That'd be a great opportunity for notification. If we could pass this out, then we could go down that road.
Mr. Chairman, I move favorable.
Got a motion for favorable and a second. Senator Coleman Madison did have a comment.
I did. Thank you, sir. Well, first of all, Representative Kiel, thank you for bringing this bill. And again, to the parents, you know, we feel your loss. Many of us have had losses in our family, so we understand this. And I understand where you are. Is anything, or is there something I can do? Can't bring back my loved one, but hopefully it'll help someone else. I like all the suggestions that have been made. I do think that parents should be notified. Maybe if the child had gotten that first warning or something like that, it would raise that red flag. And again, contrary to what some people may think, that kids tell parents everything, they don't. But let me ask a question, because I don't know. Does this, once they get a ticket, does this go on your insurance? Is it reported to your insurance?
I would assume so. Okay,
so that would be also starting now until we get all the systems in place. Again, I'm thinking that if you've got a teenager, you might want to start checking with that. But I do like the suggestion that Senator Figures and Senator Bell made, in the sense that if the system is already there in place, if there's something that we could tag on to, let's do that. Anything to notify parents and save children. Thank you.
Sure. Thank you.
All right. Any more questions or comments? He's got a motion for favorable already and a second already. Let me just say this, that if you'll remember last week, we already had adopted an amendment on this bill that said parking tickets are not, there's nothing to do with parking tickets. That was adopted last week, so I think that was a good amendment, and thanks for offering that. I'm not sure who did. All right, we're going to voice vote this. Members, again, I would ask you to consider voting yes on this, continue to work with the sponsor of the bill so that we can get it in a favorable position once we get it on the floor, if that happens. All in favor of the bill as amended, say aye. Aye. All opposed? All right, ayes have it. Bill's given favorable.
Thank you, Representative Kiel. Thank you, committee.
All right, we also have next HB 7, Representative Yarbrough.
Thank you, Mr. Chairman, members of the committee. You have before you there HB 7. I was told, I think that amendment a small amendment was sent.
Senator Van, you have an amendment you'd like to offer? Members, in your package. It just deals with counties that don't have, or places that don't have a website that they can use a bulletin board, just other. So I would move adoption.
Second
amendment.
You got a motion and a second on adoption of the amendment. All in favor, say aye. Aye. All opposed, no.
Move
bill is
favorable.
amended.
Can you let him explain this bill, please?
We're just on the amendment.
Oh, okay.
Yeah. Say that again? Can you explain that amendment again? Yeah, Senator Van.
The amendment just says that, what it says right now, the bill says a website, but because apparently some of these smaller counties don't have a website, it allows for any other form of public communication, such as a bulletin board.
Oh.
This is something coming from the counties.
Okay, yeah, you're right.
All right, so now we're on the bill as amended. Any questions or comments on HB 7 as amended?
Yes, sir. I need for him to explain this bill, because I'm curious. And I'm gonna be honest, I didn't get a chance to read this last night.
I'll be happy to explain it.
Thank you.
Yes, ma'am. So HB 7, so this is called the Lake and Riley Act. So it actually predates Senator Britt's more famous piece of legislation. It actually was passed out of Georgia last year. That's how it came to my attention. And so what this particular piece of legislation does, similar to what Georgia does, obviously Laken Riley was the young lady who tragically lost her life in Georgia at the hands of an illegal immigrant. And so what this bill does is it allows state, it's voluntary if they want to, they don't have to, but if they want to, state and local law enforcement can enter into an MOU with the federal government to help them enforce existing immigration laws. And what the bill does here is it allows them, again, if they want to help particularly focus on if there's criminal elements among illegal immigrants to help remove them from the community, to obviously keep the community safe. We've taken several amendments from across the aisle because we wanted to protect, for example, at the end of the bill, that nothing in this is going to limit or abridge anybody's constitutional rights. And then also another amendment we took was focusing on not nationality, but immigration status. And the bill also prohibits anyone from being detained solely upon the basis of their immigration status. So the focus here is, for example, the gentleman, the young lady who lost her life, the illegal immigrant, had committed a series of petty crimes up to that. And so this bill would have allowed them, which is why Georgia passed it, would have allowed them to have a structured process to get a hold of the federal immigration, ICE and so forth, and have him deported and removed before it escalated to the point where he committed murder.
Question,
Senator McCollum-Madison.
Doesn't the governor have the authority to, if there's assistance or whatever that needs to be, seems like this would be something that would come under the governor's discretion or whatever we might need if that was the case?
Currently, the attorney general can enter into an MOU, but the state and local law enforcement do not have that MOU capability. This bill would give them that. Again, it's voluntary. They don't have to. They can do it if they want to, if they see the need to partner with the federal government to help if their community has. I on my phone, I got several instances, 10, 20 instances in Alabama in recent days of heinous crimes committed in different communities by illegal immigrants who were gang members and so forth. So it would help facilitate stopping that.
So
I do, yes.
So you're saying that in let's just use Birmingham as an example, since that's where I'm from, that if they felt that there was a need for additional assistance in law enforcement, that they could enter into an agreement with the Homeland Security?
Yes,
Not mandated, but permissive.
It's permissive, right? So there it says may enter into with the Department of Justice, Homeland Security, other federal agencies like ICE for the purpose of enforcing federal immigration laws. They could. And this bill also secures that as grants or funding comes open, like from the federal government to help support this, they'd be available for that. But again, it's only if they want to. They don't have to.
Okay, thank you.
Okay, got a motion for a favorable by Senator Bell, second by Senator Gavan. Senator Figurs, you let it be recognized.
Yes, thank you, Mr. Chairman. Representative Yarbrough, I appreciate you bringing this bill, but I just have so much apprehension about voting on any of these immigration bills these days in light of what's going on the federal level. And they're not even following due process. A mistake was made when they swooped up one young man just because he had I think he had a certain type of tattoo on him or something, or was something about him, but without them even knowing or confirming, swooped him up, sent him to the prison over in where is it? El Salvador. And they're not having any kind of remorse about it or trying to get him back, although a judge has ordered them to. So I'm really just I'm all for getting the criminals off the street. I'm all for people who are not supposed to be here, that they go through the legal parameters that they should in order to make it so. But I'm just so people will say one thing or it's said one way, then there's another perspective or variation that's actually carried out. And so for that reason, I will have to vote no today, but I don't know what I will vote, how I will vote for it once it comes to the floor, once I've had an opportunity to really go through it myself. So I just wanted you to know that.
Yes, ma'am.
Thank you, Senator Figurs. We've got a motion for favorable and a second. Ms. Ogden, if you'll call the long roll for me.
Senator Alberton, Senator Bell, Senator Carnley, Senator Coleman Madison. Senator Elliott.
Aye.
Senator Figures. Senator Gavan.
Aye.
Senator Orr. Senator Singleton. Senator Smitherman. Senator Stutz. Senator Weaver. Senator Barfoot.
Aye. All right, Representative Yarbrough, the bill is given a favorable report as amended. Thank you for coming.
Thank y'all so much. Thank you.
All right, ladies and gentlemen, the last bill on the agenda today is HB 454. Representative Hurst, welcome to Senate Judiciary. If you will, tell us what your bill does, and you may even want to give, if you want to give background, that's great too.
If you don't mind, I'd like you to allow me to do this. I was going to get Senator Bell to handle it for me, and I didn't think I'd be here early enough. Let me give you the scenario what brought this up. I had a lady back in my county that works for the county commission. She came to me at a gathering. She said, "Steve, let me ask you a question." I said, "Sure." "Sometimes I have to send stuff to Montgomery. When I do, can I use your name?" I said, "Sure, that's fine." Sometime later, we had a piece of legislation we were working on. And when the legislation came down, I reviewed the legislation, and I said, "This is not what it was supposed to be." I called Osnick. He came down to my office, and I said, "I did not give this authorization for this." He pulled up his phone, looked it up, and he says, "Bill so-and-so, so-and-so, authorized by Representative Steve Hurst." I said, "That's not true." He said, "Do you know an individual by," and gave the name. I won't give the name. I said, "I do." So I said, "She's the clerk." And he said, "She said it's authorized by you." I said, "That's absolutely not the truth." So what I would like for this bill to do, the substance of the bill is to fix it to where, with one added to it, says the person is requested to publish by a member of the legislature in accordance. That means a member of the legislature has to approve on a local bill to be authorized to be published. That's the basis of it.
I appreciate you bringing this bill. I know a lot of times, especially later in the session, but even during the first part of the session, things start flying around, and what you think there's a bill or an amendment that what you think it's supposed to do, and you've been told it does, and somebody who's not authorized to take that position and insert themselves into the process that is that we have in front of us. I think this bill will help eliminate that. Senator Coleman Madison.
Thank you, Mr. Chairman. Thank you, my friend, for bringing the bill. I think it's a good bill, but I'm just wondering if we need to make it a law, simply because I believe at the beginning of the session, or maybe it was the end of last session, we got a notice or something about procedures of what you need to do to give persons authorization. Am I the only one that got that, similar to that? As when you are LSA, when you are sending something up to LSA, or who can sign off on it? I mean, like our legislative staff, the person in my office, and typically, people that come to us with lobbies or agencies that we're working with, like the Secretary of State bill that I'm working on, and even that person who with the Secretary of State's office, he says, "Okay, I need to get this drafted as an amendment. Can you, tell him that you say?" I say yes. So I let my administrative assistant in the office know, that LSA know that he's going to come up and he's going to have this bill, the amendment drafted up. I thought we got something from them. Am I correct?
So, Senator, what we did.
You remember?
But early on, I guess in this session, we adopted a rule within LSA that said that basically what was happening is that some legislators were signing blank endorsements, like 60, 70 of them, and basically just allowing LSA to be their free law firm for their lobbyists and whatnot. And we clamped that down to say you have to have it has to be germane, can't just be education matters. It's got to be, specific of what you're working on. But that's a limitation of who can use the LSA people, because those are resources paid for by the state, and they shouldn't be just, available for every lobbyist to have their own law firm. And they were also taking up time. They weren't getting to our bills and amendments because they were so busy working for them.
Okay, so Representative Hurst is specifically, just give me the bullet points here of exactly what this does, and does it make it a crime or what?
It's a misdemeanor.
It's a misdemeanor. May I add something to this while we're
Certainly,
talking?
go right ahead.
Also, I noticed in this particular piece of legislation, there were several pages that was added to it when it was advertised. It's on several pages, line after line after line was going through. So that tells me the next time that's published, it comes back out, everything's been thrown out that existed. Because of this, the sheriff lost his vote. He was supposed to get. Other people lost his vote. Instead, it went into one pot. That was not the way it was structured to start with. That concerns me. I've always thought about that. But if they're going to draw the lines through it and it disappears, you know, I was guilty of not catching it at the proper time. But now that I've caught it, some kind of way we need to fix it.
Mr. Chairman, move favorable.
Got a motion for favorable by Senator Elliott, second by Senator Gavan. Any other questions or comments?
Yes, I have a lot of reservations here. I'm just trying to, if someone would tell me, how does this work? Okay, I advertise a local bill. This is basically with local bills. We advertise a local bill. Usually local bill advertisement come from some resolution by one of our local entities, 90% of them, right? Either gonna come from school boards or city council or county commission. We want. It's being advertised. Now, take it from there. It's been advertised, and you're saying once you get the bill back, the advertisement doesn't match the wording in the bill because someone has allowed LSA to alter that?
No, LSA did not alter it. It was altered when it sent down. It was within the advertisement by the lines drawn through it when it came back down. It was not.
But the offer of proof should match the bill, though. And LSA could see that based on what is being the proof from the advertisement. It should match the bill.
And I think in your scenario, what you correct me if I'm wrong, that what was advertised was not the same, and so even if you'd have caught that advertising had already gone out, and that advertising had been changed by an individual who did not have that authorization.
That's correct, because I did not authorize that individual to do so, but it was, when Anthony read it out, said it's authorized by, and called the clerk's name.
He wouldn't have been the one who authorized the advertisement. That's what I'm understanding. Because the advertisement is what goes in the paper, word for word. Okay, it has to be clipped out, sent up here with the bill. That's when LSA should be copying what's from the paper into the bill. That's why I'm understanding where does the change come in at, that LSA can't recognize the difference.
Senator Bell.
Representative, correct me if I'm wrong. She used your authorization, she got it, she advertised it. It was not, you didn't really see any of it until after the advertising had occurred.
Well, number one,
Is that,
I didn't authorize her on that particular piece of legislation.
She just used a previous authorization.
Her question to me was, sometime I need to send things to Montgomery. When I do, can I use your name? I said, yes.
you didn't know about any of this had happened until after it already been, the bill had been drafted, advertised, and everything. It was already session time before you found out she'd even done any of that.
That's correct.
But you don't have to introduce it. So when does it become a misdemeanor? Because you don't have to introduce it. Is there harm? There ain't no harm, no foul if it ain't been introduced and cause harm back home. It's just been written up. So how do I get a misdemeanor for something of that nature for that? No harm, no foul yet.
Understand.
Okay.
We got a motion for favorable by Elliott and Senator Gavan is the second. Ms. Ogden, if you'll call the roll for us.
Bell? Senator Cornley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton?
You my friend, I'm gonna say yes because you my friend.
Senator Smitherman?
I'm like you always remember.
Senator Stutz? Senator Weaver? Senator Barfoot?
Aye. All right, Bill's given a favorable report. Members, that concludes the agenda for today. There is the possibility Representative Tillman has a bill that came up late last night that I've told him we would try to get on today. We didn't have enough time to do that. There may be one other bill, so we may have to have a committee meeting. If that happens, that could be tomorrow before we go into session. I need to check the availability, so just a heads up on that, okay? Thank you.